due diligence. This is a phase of the business sale that most sellers dread. A team of accountants and lawyers are going to go through everything. Every contract, every financial statement, every corporate record, every customer relationship, every employment agreement, every regulatory filing. It feels like an audit. It feels like judgment. And for the seller who isn't prepared, it's the phase where most deals fall apart. A price reduction, a demand for a specific indemnity, a buyer who gets cold feet and walks away. All these outcomes are far more likely when a seller goes into due diligence unprepared. This episode is about preparation, what buyers are actually looking for, how to organize your information and present your business at its best, and critically, how the disclosures you make during due diligence protect you legally after the deal closes. I'm Chad Graham. I'm an Alberta corporate lawyer and host of From Build to Sold. This is episode 8, the due diligence episode. If you've been following the series, you've done the corporate cleanup, you've worked through the LCGE analysis with your CPA, you've negotiated a solid LOI, and you've settled on a sales structure. Due diligence is what comes next. Due diligence is the buyer's investigation of the business they have agreed in principle to purchase. It's the process in which they verify that what you've told them about the business is true, and that there are no material issues that they didn't know about when they sell the LOI. It's not an opportunity for the buyer to retread the deal in every minor issue they find. It's not a fishing expedition to find reasons to reduce the price. A well-run due diligence process with a well-prepared seller is a verification exercise, not an interrogation. That said, material issues discovered in due diligence will be dealt with. A buyer who finds a significant undisclosed liability, a broken contract, or a CRA dispute that was not disclosed will either demand a price reduction, require some specific indemnity, or potentially walk away. The way to prevent that outcome is preparation, preparation, preparation. Find those issues yourself before the buyer does and decide in advance how you want to address them. The data room. The primary tool for due diligence is called a data room. It's a secure, organized online repository of all documents and information the buyer's advisors will review. You control the data room. You populate it. You decide what goes in it and in what order. So a well-organized data room is not just a logistics tool, it's a signal. It's a signal to the seller or about the seller. A seller who presents a clean, complete, well-indexed data room signals that they want run a well-organized business. A seller who provides documents in a disorganized heap with gaps, missing dates, and inconsistencies, well, that signals the opposite and gives the buyer's advisors a reason to dig deeper. Presentation matters. Organization matters. Completeness matters. Area 1, financial due diligence. This will be led by the buyer's accountants. They'll review 2 or 3 years of financial statements, tax returns, management accounts, accounts receivable, aging, accounts payable schedules, inventory records, and working capital history. They'll rebuild your normalized EBITDA from scratch using their own methodology. What they're looking for is this. They're looking for consistency between your financial statements and what you've represented on your CIM and your LOI. They're looking for revenue quality, for customer concentration, for unusual items, related party transactions, anything that suggests the numbers are not exactly what they appear to be on the surface. So what you need to have ready: clean, reconciled financials with clear documentation of all normalizing add-backs. If your CPA has prepared a quality of earnings analysis in advance, bring it. This demonstrates professionalism and can often reduce the scope of the buyer's financial investigation. Area 2, legal due diligence. This is my domain, and it's the area I want you to understand the most clearly. Legal due diligence covers corporate records, the minute book, share register articles, any amendments, all material contracts, customer supplier, employment leases, service agreements, licensing agreements, litigation history, any current or threatened legal proceedings, intellectual property, ownership, registration licenses, permits, regulatory approvals, and for a share sale, a PPSA search against a corporation. Now, the minute book review is the first thing a buyer's lawyer does. Under the Business Corporations Act, a corporation is required to maintain a current and accurate corporate record. Gaps in that minute book, undocumented share transfers, missing resolutions generate questions and slow the process, creating leverage for the buyer. If you've done the work we discussed in episode 3, this should be clean. Contract review is the second major focus. Every material contract goes into the data room. The buyer's lawyer will review each one for assignments and change of control provisions, termination rights, unusual terms, and anything that doesn't survive a change in ownership. Area 3 is then operational due diligence. The buyer wants to understand how the business actually runs. Key customer and supplier relationships, are they durable? Key employees, are they staying? Systems and processes, are they documented? IT infrastructure, is it current and secure? For Main Street businesses, operational due diligence is often much less formal than financial and legal, but sophisticated buyers, particularly acquisition entrepreneurs who have done multiple deals, well, they'll ask pointed questions about owner dependence, key employee retention, and the reliability of systems. We discussed this in episode 2. If you have already addressed those issues in advance, you'll be in a strong position. Now, real property, area 4. If the business occupies a leased premises, the commercial lease goes in the data room. The buyer will be looking at the remaining term, the renewal options, the rent escalation provisions, and of course, critically, any assignment clause. If the lease requires landlord consent on a change of ownership or an assignment, that consent needs to be obtained before closing. A buyer who gets to closing day without landlord consent has a serious problem. If the business owns its premises, then of course a title search is going to happen. And then area 5 is employment matters. Buyers will review your employee roster, compensation structure, and any employment agreements. They want to know who the key people are and whether they are under contract and whether they're likely to stay after this transition is complete. Now, a quick note on privacy. When you disclose employee information in due diligence, you're disclosing personal information. Alberta's Personal Information Protection Act, PIPA, requires this disclosure be proportionate and limited to what is necessary for this transaction. So your NDA should cover how this is used and what they will get. Now, the most important legal concept in this episode is what you do in your representations, warranties, and your disclosure schedule. Remember that. It's the thing that will protect you or fail to protect you after the deal closes. So pay attention to this. In the purchase agreement, you as a seller will make representations and warranties about your business. You're representing, for example, that your financial statements are accurate, that there's no undisclosed litigation, and that all material contracts are in full force, that the corporate record is complete and there are no undisclosed liabilities. These representations survive closing for a negotiated period, but usually a year or 2. And if they turn out to be false, you can be sued. The disclosure schedule is the document that qualifies those representations. It has a list of exemptions, facts and circumstances you're disclosing now. And if a matter is properly and fully disclosed, they cannot form the basis for a future warranty claim against you after closing. A material matter that is not disclosed can. The disclosure liability is your primary protection against post-closing liability. It's not the place to be economical with information. I want to address one instinct that I often hear many sellers have at this point. It is, if I disclose a problem, the buyer will use it to reduce the price or walk away. That instinct's desirable, but it's also wrong, or at least backwards in its risk assessment. A problem that is disclosed at the disclosure schedule stage is a problem priced into the deal, and that is closed. A problem that is not disclosed, but the buyer discovers after closing, is a problem that generates a warranty claim, potentially for the full value of the loss, plus legal costs, plus years of litigation. The disclosure problem costs you something on the negotiation table. The undisclosed problem can cost you far more in court. Disclose everything material. Have your lawyer help you draft the disclosure schedule carefully. This document is as important as the purchase agreement itself. Okay, how do you prepare? Here's some practical things. Have your lawyer conduct a full minute book review and update. Resolve any gaps in the corporate record. Have your CPA prepare and review a normalized EBITDA analysis that you can stand behind. Pull any material contracts and have your lawyer review them for assignment provisions and change of control clauses. Confirm the status of all business licenses and permits. Run the PPSA search, identify and arrange to discharge any outstanding security interests. And if you own real property, arrange a title search. Consider whether environmental assessment might be appropriate. And think carefully about your disclosure schedule now. Identify every material issue in the business not reflected in the general warranties. Write it down. Review it with your lawyer. Now, a little note, during the due diligence process, respond to requests promptly. A seller who is slow to provide information signals disorganization, or worse, that they are hoping the buyer doesn't look too hard at something. Channel all buyer communications through your representative advisors, where possible. Off-the-cuff responses to pointed questions from a buyer's lawyer could create problems down the road. Let your team manage the process. Treat every issue that surfaces as a negotiation, not a crisis. Most due diligence findings are indeed manageable, with the right structure, the right indemnity, or the right price adjustment. Your lawyer's job is to help you find the right solution. Due diligence does not have to be the phase where deals die. For sellers who are prepared, who have a clean record, complete documentation, and a clear understanding of their disclosure obligations, it's simply the verification step before closing. The seller who struggles in due diligence are the ones who treat preparation as something to do once a buyer shows up. Sellers who are confident are the ones who treat it as something to have years in advance. Episode 9 will take us from the signed LOI all the way through closing day in a kind of giant survey. The purchase agreement, the conditions, the mechanism of closing, and what actually happens when the deal is done. If you would like a pre-sale audit, a review of your corporate records, key contracts, and disclosure positions before a buyer's team starts looking, visit chadgrahamlaw.com. That's exactly the kind of work we do, and it's far less expensive than the alternative. I'm Chad Graham. I'll see you in episode 9.